Well, good evening, everyone, and welcome back to AJ102, Introduction to Law Enforcement and Criminal Justice. Tonight's lecture is going to be on Chapter 2, The American Quest for Freedom and Justice, Our Laws. A couple of really quick things before we jump into the chapter. Don't forget to utilize the key terms that are located at the beginning of each chapter and take the time to also go through those discussion questions at the end of the chapter. I also think it would be a great idea that you would read each chapter in your textbook thoroughly so you can add context to a lot of the things that we're going to be talking about. Now remember, because there's such a large amount of information, if you will, I'm not going to be able to cover everything, so this would really help you, again, add some context as we go through a lot of this information and hit a lot of the highlights. So here we go. We're going to jump into Chapter 2. I'm going to skip past the learning objectives like I did in Chapter 1 just for sake of time, because I'm sure that because you guys are all awesome students, you've already gone through all of these learning objectives. As a matter of fact, you've probably read the entire chapter already. So question, what do these two pictures symbolize to you? And I'm not going to give you a lot of time to answer in your head, if you will, but you can look on the right and you can see the scales of justice, which could represent fairness or jurisprudence or law or things like that. But on the left, we have kind of an addition to the photograph. We have a woman holding up the scales, and I would ask that you take a second and kind of put some thought into what you believe this picture signifies. If you haven't met Lady Justice before, well, here's the introduction. This is, in fact, Lady Justice. Now, in Western law, she has become the symbol for fair and equal justice without corruption or favoritism. Often, she is blindfolded to represent the idea that the judicial system is impartial and, in fact, blind, if you will, to anything but the facts. Now, she usually carries with her a sword for enforcement and the scales for equality. So if you've never seen that photo before, it truly has a significant impact on Western law and how it is in fact viewed. Now, before we leave these pictures, I will leave you with a quick quote from Thomas Jefferson to get us going. We hold these truths to be self-evident, that all men are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. Now, speaking of life, liberty, and the pursuit of happiness, this is perhaps the most well-known phrase in the United States Declaration of Independence. And this has also become the very sentiment radical jihadists have attempted to suppress in their efforts to terrorize Americans and lead our country's citizens to live in fear, thus a brighter than ever spotlight on the issue of civil liberties and privacy interests. And I open with this kind of information to get you thinking about a case that we're going to go over here in a minute to show you how difficult it is to balance justice and civil liberties. It's a very, very tough thing. So in the aftermath of the December 2nd, 2015 mass shooting in San Bernardino, California by Saeed Farook and Tashfeen Malik, investigators sought access to Farook's Apple iPhone for clues about what led to the attack and information on others who may have been involved. Now, this move added new spark to the already contentious debate surrounding government intrusion into citizens' communications. So the desire to balance the needs of society with the rights of the individual is in fact a fundamental element of law. And when you think about that situation that I just spoke of on that case, it can be very easy for us to say, hey, you know what? just give us the information. But to ensure each U.S. citizen the right to life, liberty, and the pursuit of happiness, those who settled here establish laws that, you know what, all of us are expected to obey. Now, that might be a tough pill for everybody to swallow, and some of you are going to say, hey, we should have just been able to get that stuff, and some of you are going to say, hey, maybe we shouldn't get that stuff without some kind of due process or whatever. But no matter where you sit on the issue, I hope that you're thinking about it, because it is difficult, again, to balance those scales of justice. And when you get into law enforcement, you will see that it is a difficult task, to say the least. Now, moving on, the supreme law of the land is embodied in the United States Constitution and its Bill of Rights, and we'll look at the Bill of Rights later. Our system of laws are extremely complex. They are, and they may be classified according to what you see below here. So form, which would be written or unwritten common law; source, which would be constitutional, statutory, or case; parties involved would be public or private; and the offense would be criminal or civil. So this is how we might classify some of these things. Now, what is a law? Well, a law is a body of rules for human conduct set by the government and enforced by imposing penalties for their violation. And as such, a law is a formal social control mechanism, as distinguished from or opposed to other more informal types of social control, like etiquette or ethics or customs. And when you talk about social or moral law, obedience to law is often obtained through social pressure or ridicule or contempt or even ostracism. Now, there's a thing out there under precedent, so where we talk about common law and case law. Well, the beginning of law can be found in social customs. And customs or custom is simply precedent, meaning doing what has been done before. And some of those early customs have, over the centuries, actually become law. So again, the beginnings of law are found in social customs, and custom is, again, simply precedent, doing what has been done before. Now, in early times, custom, religion, morals, and the law were kind of intermingled. And as we just said, some early customs have, over the centuries, actually become law. And precedent, by nature of its long history of acceptance and the momentum gathered from this longevity, explains why many good ideas in criminal justice are so slow to materialize. It can often take a long time to get people to agree to change the way that things have kind of always been. Now, in early England, common law referred to the precedent set by the judges in the royal courts as disputes arose. The common law was brought to the United States by the early settlers, which formed the basis of our modern American law in all states, initially except Louisiana. In essence, common law describes the precedent generally followed in absence of any specified law. Now, California doesn't recognize common law, along with some other states, and I'm not going to kind of go way into that. We recognize what we call statutory law, and we'll get to that in a minute. And you can kind of look at it like this. Common law, again, would be those customs that have evolved over time where there's nothing necessarily written down, as opposed to statutory law, which would be written law or laws passed by legislation. So again, in essence, common law describes the precedent generally followed in absence of a specified law. Now case law refers to judicial precedent. No specific law actually exists, but similar cases serve as a model. And the case I have before you here, Terry versus Ohio, yes, it's an old one, 1968, but this is a historic Supreme Court decision. And this is a United States Supreme Court decision that I would suggest that you would actually use this link here and go to the case and read the case, because it is one that is of historic significance. But this is where, again, case law is a collection of summaries of how statutes have been applied by judges in various situations and those precedents established by the court. So again, judges will use these case laws to help rule on other cases. So staying with what is law, we'll look at statutory law. Well, the United States has largely replaced, as I said a minute ago, common law, which was unwritten law, or remember, we've always done it like this before type law, so we're going to keep doing it like this because it's been that way all along, and we're just going to do it like that with what we call statutory law, which is written law. Now, statutory law may be passed at the federal, state, or local level and includes constitutional, criminal, and civil law. And each state has the power to create laws as long as that legislation or those laws don't preempt the federal law or the U.S. Constitution. And there's a term also that I wanted to go over, which is called federalism. And well, you know what? I'll get to that in a minute. So let's just keep on going. So along with laws, so we've kind of gone through, what is a law, and we've talked about common law and case law and statutory law. Let me add one more to the mix, called ecclesiastical law, which is basically law of the church. So we'll kind of make sure we cover them all. And then one other one I'll add, which will be ordinances or local ordinances. So in addition, most states and each county and city are given the right to pass laws for local jurisdiction, providing, again, that law does not conflict with the state laws. And local ordinance are laws primarily enacted to protect the community. So those are local laws or regulations. So now that we've ran the gamut on laws, we'll turn to a term called equity, which is a concept requiring that the spirit of the law take precedence over the letter of the law. So the need for laws to change as society changes has long been recognized, and equity demands that laws change as society changes, restoring to general principles of fairness and justice wherever existing laws are inadequate. So fixing what doesn't work. And I gave the example in a prior chapter of cell phones, where we really didn't need laws regarding cell phones and driving before because the technology wasn't there, etc. Well, now we have such technology, and because we need these laws in place so people aren't killing each other out there and crashing and injuring people because they're on their phones, this would be one thing where we really need a law because of our changing society as it relates to available technology. Now, when we talk about fairness and justice, what we're saying also is that the spirit of the law take precedence over the letter of the law. And this can be taken in a couple of ways. So the spirit of the law meaning fairness and justice, take place over the letter of the law, the just black and white issue. We also police in that same manner. So I'm going to kind of go off on a quick little spiel here, where law enforcement has the same phrase in their mind, where they might use their discretion more in the spirit of the law versus the letter of the law. Example could be maybe writing somebody a ticket. While that is discretionary, the spirit of the law could actually look at fairness and other things that were going on at the time. The person may have been going too fast on the freeway, etc., versus the letter of the law, which is the black and white code that says if you go this fast, you are going to get a ticket. But again, equity demands that laws change as society changes as well. Now, as we move into the Supreme Court and talk a little bit about that, I want to make sure that we cover a couple of things relative to the Declaration of Independence. So the Declaration of Independence, okay, asserts that all individuals are created equal and are entitled to the unalienable rights of life, liberty, and the pursuit of happiness. It further asserts that governments are instituted by and derive their power from the governed, that is the people. Now, typically, each state Supreme Court is granted the final interpretation over case law, unless, of course, that interpretation may involve some type of a federal issue. Now, when this is the case, an appeal can be made to the United States Supreme Court via what they call a writ of certiorari, which is a formal written request for a judicial review. So again, certiorari by definition is an order by a higher court directing a lower court to send for review the record in a given particular case. So now we're going to move into the Declaration of Independence, and we're going to talk about this American Creed thing, and we're going to look at individual freedom and civil rights and civil liberties and checks and balances, meaning is there a check and balance in there somewhere to help us ensure law and order? Well, the American Creed is the national conscience, if you will. It's a body of beliefs about equality, liberty, and justice, which most Americans believe in spite of the fact that America has and always had multiple wrongs. And in the 1760s, the British began taking away rights Americans felt were naturally theirs. And the American Revolution resulted because of that. And in effect, the United States was born out of desire, indeed demand, for civil rights and civil liberties. And civil rights are those claims that citizens have to the affirmative assistance of the government. So let me say that again since I stumbled a little bit. Civil rights are those claims that citizens have to the affirmative assistance of the government. Now, civil liberties are an individual's immunity from governmental oppression. And when we go back to like that Declaration of Independence thing that I talked about, I think it's important that we understand how these two pieces kind of fit in. Now, the Declaration of Independence asserts that all individuals are created equal and are entitled to the unalienable rights of life, liberty, and the pursuit of happiness. It further states that the governments are instituted by and derive their power from the governed, and that is in fact the people. And the Constitution, to go a little bit further, is a system of fundamental laws and principles that prescribe the nature, functions, and limits of government or other body. Now, the colonists cherished the freedom from tyranny that they had fought for and wanted to ensure that when they set up their new government, that no single entity would have absolute power. They also, however, wanted to ensure that law and order were a part of this new country, and the importance of a system of checks and balances and establishing entities that could ensure law and order is seen in the first 3 articles of the Constitution. So we're going to kind of go a little further. So the Constitution, again, is a system of fundamental laws and principles that prescribe the nature, functions, and limits of a government or or other body. Now, the U.S. Constitution, ratified in 1789, is that basic instrument of government and the supreme law of the land. Well, the U.S. Constitution also laid the foundation for the criminal justice system by establishing 3 different parts to that. So instead of one person or group having responsibility and authority over all of these, they made them separate. So it established the legislative branch to make the laws. It established the executive branch to enforce the laws, and the judicial branch to judge when a law was broken. And then the last thing would be federalism came into play, which allowed the criminal justice system to develop at the state and federal levels, thus a balance of power. So federalism can be defined further as a principle whereby power is shared by the national government and the states. So if you could think of another right that you would want enumerated in the Constitution, what might that be? Interesting. So now let's take a very quick look, okay? Because I'm gonna have you read some of these on your own, but we're gonna take a very quick look at the Bill of Rights, which would in fact be the first 10 amendments to the Constitution. And I posted this earlier in the module, so you should be able to see it, but we'll go through it again. And in this PowerPoint, I also have some links to some videos if you want to get a little bit more information. So we know the Americans declared their independence from Great Britain in 1776. In 1787, they adopted the United States Constitution. And some states still thought, though, that the Constitution didn't say enough about the rights of the people. So in 1791, Congress added the first 10 amendments to the Constitution, and the first 10 amendments are called the Bill of Rights, and I'm going to throw in the 14th because it's cool. And these are individual rights that the government cannot take away. So the First Amendment, well, I don't want to read every single thing in here, but we're going to go to kind of a shorter, more condensed version. So the First Amendment talks about freedom of speech and freedom of religion, freedom of the press, the right to peaceably assemble, the right to petition the government for redress. And the Second Amendment talks about the right to keep and bear arms and gun ownership issues, and even incorporates the Brady Law. Well, the Third Amendment guards against the forced quartering of troops, because in the years before the American Revolution, British officials forced the colonists to quarter or house and feed troops. The Fourth Amendment forbids unreasonable search and seizure. And there's something in there where it talks about requiring probable cause to seize individuals or to search individuals, and that also extends to search warrants, making sure that no warrant is issued without probable cause. And there are 2 what we call major Supreme Court precedent cases that I would suggest that you look at that make up this thing called the exclusionary rule, and that would be Weeks versus United States and Mapp versus Ohio. Those are must-read cases. And the Fifth Amendment talks about no double jeopardy. and the meaning being tried twice, or the privilege against self-incrimination, and no deprivation of life, liberty, or property by the federal government without due process. The Sixth Amendment establishes requirements for criminal trials: a speedy public trial by an impartial jury of one's peers, to be informed of the nature and cause of the accusation, to be able to confront witnesses and cross-examine witnesses against oneself, to be able to use the subpoena power of the court and subpoena witnesses in one's defense, and also to be represented by legal counsel. The Seventh Amendment, which lays out the rules of common law. And again, I'm going through these quickly for the sake of time. The Eighth Amendment, which covers things like excessive bail or excessive fines, and also cruel and unusual punishment, which deals with issues like the death penalty and such. And the Ninth Amendment, which ensures that the individual rights that are not enumerated or written down or listed in the Constitution are still secure. That is, that these rights should not be automatically infringed upon just because they're not written down. And the 10th Amendment, which talks about power to the states. So the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. And the 14th Amendment, because I just threw it in there, really talks about due process, specifically orders state and local officers to provide the legal protections of due process under the law. Look at the bottom in the right-hand corner there. All people are created equal, so no denial of equal protection under the law. So yeah, I went through those pretty quick, but the expectation is that you're going to go back and you're going to read these in a little bit more detail, or you can just go through the PowerPoint that I have that talks about the Bill of Rights, and even has some links that are listed on those on those slides as well. And that'll help you kind of understand some of those in more detail, if you will. So now that we've gone through the Bill of Rights, let's talk about the incorporation doctrine. Considering that the Constitution's primary purpose was to limit the power of the federal government, it made little sense to hold the federal government in line only to leave the state authority out. So the incorporation doctrine holds that those provisions of the Bill of Rights fundamental to the U.S. legal process are made applicable to the states. So hopefully that kind of makes sense to you. So any of those amendments that we went over seem more important than the others? And I don't know. It's just kind of, food for thought as we talk about that. So now we're going to talk about defining crime and fixing punishment and what criminal law is. And there'll be a couple of different phrases that we'll go over. Criminal law is basically defined as the body of law that defines crimes and assigns punishment for them. Now, under there, you're going to see two different things. You're going to see substantive criminal law, and you're going to see procedural criminal law. And if you're following along in your textbook on page 61, there's a whole list of definitions there that I would really suggest that you kind of go through, because I'm probably not going to be able to hit every single one of those. So when you talk about defining crime and setting punishment, which is substantive criminal law, the Bureau of Justice Statistics defines crime as all behaviors and acts for which a society provides formally sanctioned punishments, and crimes are made so by law. An act, no matter how offensive, is not a crime unless a law exists to define it. State and federal statutes define each crime, the elements involved, and the penalty attached to each. the statutes that define what acts that constitute social harm are called substantive criminal law. So substantive criminal law, the statutes that define what acts constitute social harm. It defines the act and also the punishment. So hopefully that kind of, you understand that. Now, procedural criminal law is a little bit different. So proving that a crime has been committed, which is more procedural criminal law. So in addition to establishing what specifically constitute a crime and the punishment for it, procedural criminal law specifies what must be proved and how, that is legally, within the constraints of the Constitution and the Bill of Rights. So to prove that a crime has been committed, it's usually necessary to prove a couple of different items here, and we're going to look down there. So go to the middle of the slide first when we're talking about procedural criminal law. So remember, to prove that a crime has been committed, it's usually necessary to prove a couple of different things. One would be the actus reus, okay? The material evidence of the crime, including planning and conspiring, or in other words, the material elements of the crime. And then mens reus, okay, or mens rea, which would be the criminal mental state, literally the guilty mind, or the intent to do wrong. And you'll see some of these definitions again on the right side of your page. So actus reus, as defined, a guilty measurable act, including planning and conspiring. And then mens rea would be guilty intent, literally the guilty mind. And crimes have also been classified as what they call mala in se, meaning bad in itself, and mala prohibita, meaning bad because it's forbidden. Now, a mala in se crime is one so offensive it's obviously criminal. So something like, let's say, murder or rape. A mala prohibita crime is one that violates a specific regulatory statute, like traffic violations. Those would not usually be considered crimes if no law was there that prohibited them. So hopefully it I've kind of cleared those up. Now there's also some other definitions on the side, like a felony, which is a major crime, like murder, rape, arson, and the penalty is usually death or imprisonment for more than 1 year in a state prison. Or a misdemeanor, which is a more minor offense, for example, breaking a municipal ordinance or something like that, or maybe drunk driving, and the penalty is typically a fine or a very short sentence of imprisonment in, let's say, a local county jail or something like that. Along with that now, and let me go back and just talk about corpus delicti really quick. So corpus delicti, when we talk about material elements of the crime and the criminal act, basic to the commission of a crime is the concept actus reus. We talked about that, literally the guilty act. The actus reus must be a measurable act, including planning and conspiring. Now, contrary to popular belief, the corpus delicti of a crime is not the body of a murder case. That gets kind of mixed up in there. It is quite literally the body of the crime itself, the distinctive elements that must exist for a particular crime to be proven or proved. These elements of the crime make up the corpus delicti. And hopefully that kind of helps as well. So go through some of those definitions on there, and you'll be able to kind of sift through them and have a better understanding of that. So now let's move on to civil law and torts and some different distinctions between the two. And we'll go into a little bit more detail in a minute, but the criminal civil distinction is of interest to law enforcement officers because they must deal with those who break criminal laws and at the same time not violate the criminal civil rights. And officers who do not deal legally with criminal matters may find themselves targets of lawsuits as well. And in addition, law enforcement officers must be able to tell the difference between a criminal and civil offense because they are responsible for investigating typically only criminal matters. So we'll talk a little bit more about civil versus criminal in just a few minutes, but we're going to move into what we call the Civil Rights Act, which is Section 1983. So the Civil Rights Act, Section 1983, states in part, okay, every person who under color of any statute, ordinance, regulation, custom, or usage of any state territory subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privilege, or immunity secured by the Constitution and laws shall be liable to the party injured in an action at law, suit in equity, or other proper proceedings for redress. So, in other words, anyone acting under the authority of local or state law who violates another person's constitutional rights, even though he or she is upholding the law, can be sued. So, but don't panic on that, okay? There are two basic requirements that go along with that for that particular Section 1983. And one is that the plaintiff must prove that they were deprived of a constitutional right, and two, that the defendant must deprive the plaintiff of his right while acting under color of law. And with that comes different levels of basically intent. So similar to criminal law, civil law has levels of intent, and we'll touch on those briefly. Strict liability is where the wrongdoer is liable even if no harm was intended. For example, keeping wild animals in your house, which is a violation of law. An intentional wrong is where the person knows the act was unlawful but did it anyway. And then negligence would be where the person did not set out to do harm but acted carelessly. So now we're going to kind of come back a little bit to civil law versus criminal law and civil law and tort so we can show you the difference between the two. So civil law refers to all non-criminal restrictions placed on individuals. It seeks to not punishment but restitution, meaning like money. And typically that's what it is. And this type of offense is called a tort. And you can look at the slide here and you can see the difference between a crime and a tort. So a crime is a public wrong and a tort is a private wrong. Under crime, the state prosecutes, and under tort, the individual prosecutes. Under crime, typically seeks to punish, and under tort, seeks redress for injury. And redress, again, means some type of compensatory type value, like money. And then under crime, there is a criminal intent, and under tort, there is no intent necessary. But if you go back to those basic requirements I told you or talked about, there are those three things that we looked at. So similar to criminal law, remember, civil law has levels of intent that are called strict liability, intentional wrong, and what they call negligence. So now we've kind of walked through some of the really more difficult things, if you will, and let's start to look at enforcement and where police draw their power from. So where do police get their power? Well, without means of enforcement, the great body of federal, state, municipal, and common law would be pretty much empty and meaningless. Now, recall that law implies not only the rule, but also the enforcement of that rule. All forms of society rely on authority and power, and authority is the right to direct and command. Power is the force by which others can be made to obey. Police power describes the ability of federal, state, or municipal governments to enforce the laws they pass by granting government agents at each level the authority to use force against those who fail to comply with laws. So where do we get our power, though? Well, we get our power from the U.S. Constitution, from the U.S. Supreme Court decisions, from federal statutes, from state constitutions, from state statutes, state court decisions, or various municipal charters or ordinances. These are areas that we get our power from. And if you look on page 68 in your textbook, you can see kind of a diagram there. It's under figure 2.2 that basically depict sources of police authority and sources of police power. And it kind of shows us there, where we get that information from. So how do we view social control? And when we talk about needs of society and individuals' rights and things like that, how do we balance the needs of society and the rights of the individual? And there are a couple of theories that are going to kind of come to the forefront as we talk. Well, the United States of America was founded on the desire for liberty and freedom from England's tyranny. And although the founding fathers crafted our government to ensure it would not impinge on individual liberties, the desire for law and order was also strong. They had brought with them the common law of England, and it was expected that these laws would be obeyed. Now, we looked at those pictures earlier. The scales of justice symbolize the desire to balance the needs of society with individual rights. Now, back to my discussion here, this tension between society's need for individual liberty has its roots in two conflicting views of social control, and they're called conflict theory and consensus theory. Now, conflict theory contends that certain behaviors are criminalized to keep the dominant in power. And consensus theory holds that individuals within a society agree on basic values on what is inherently right and what is inherently wrong. Now, these two opposing views of social control parallel the two competing models within the criminal justice system, which would be crime control and due process. And we're going to talk a little bit about these two things right now. So crime control versus due process. Well, a major function of our criminal justice system is crime control. However, the Fifth Amendment of the Bill of Rights and the 14th Amendment both guarantee citizens due process of law. Due process of law was defined in the Magna Carta as the law of the land, and although the different state Supreme Courts have given varying definition, the basic meaning of due process is that all legal proceedings will be fair and they'll be just. In other words, due process is a constitutional guarantee that no law or legal proceeding shall be unreasonable, arbitrary, or capricious, separate value systems that compete for priority in the operation of that criminal justice process. Now, the crime control model is seen as kind of an assembly line justice, which is more administrative than adversarial, focuses on law enforcement component of the system and pretrial activities, and relies on discretion, efficiency of operation, facts, and repression of crime. Crime control emphasizes collective needs and the idea that all offenders should receive the harshest penalty allowed by law. Now, the due process model, in contrast, views the process as kind of an obstacle course justice that focuses on the judicial component of the system relying on laws, emphasizing reliability, and seeking to preserve individual liberties. Due process contends that offenders should receive the least severe penalty, and that the state must justify more severe penalties. So that's kind of crime control versus due process, and you can read a little bit more about it in your textbook. Well, what about conservative versus, say, liberal crime control policies? Conservative crime control policies are draped explicitly in the metaphors of war. We have declared war on crime and war on drugs, which are presumed to promote crime. Criminals, according to this view, have taken the streets, blocks, and sometimes entire neighborhoods from law-abiding citizens. The function of crime control policy is to recapture the streets from the criminals to make them safe for the rest of us. In contrast, liberal crime control approaches emphasizes correctional policies and broader social reforms intended to expand opportunities for those, as they say, are locked out of the American dream. So you can kind of see the difference between those two policies. Now, do you think that the police have too much power or too little power when we talk about stuff like this? So let's finish up with a couple of items that are again very, very interesting. It's retributive versus restorative justice. And the evolution of our criminal justice system involved a shift from the community caring for itself and taking action against those who broke the rules to a system whereby the king or the ruler took on that responsibility. Now, under this new system, a person who broke the rules or the law must pay. Remember that lex talionis type phrase I used before, an eye for an eye, or what would be known as retributive justice. And in the United States, crime is still most often viewed as an offense against the state rather than an offense against an individual. So by definition, retributive justice is a system in which a person breaks the rules, must pay, kind of an eye for an eye. Now, restorative justice is a philosophical framework that focuses on crime as an act against another individual rather than against the state, and focuses on harm done and really how that harm could be repaired. The goal of restorative justice is to reconcile the needs of the victims and offenders with the community needs, unlike retributive justice, which is primarily concerned with punishing crime. Restorative justice focuses on repairing the injury that the crime inflicts. So restorative is more about reconciling the needs of the victim and the offender. And with that, and along with that, we're going to talk about law and policy and discretion, because this does play a role in how this whole criminal justice system kind of plays out. And we're getting close to being done. Discretion is the freedom to make judgments that not only affect individuals, but the entire criminal justice system. Discretion is found throughout the criminal justice system and is exercised by legislators, police, prosecutors, judges, correctional officers, and paroling authorities. Police, for example, use discretion when they decide whether or not to enforce specific laws. Prosecutors, opportunities use discretion to include whether to file charges or seek indictments or offer plea agreements or to reduce charges or even drop cases. Parole boards are allowed discretion when determining whether to release inmates from institutional confinement before the completion of their sentence. Now, some believe that there should be one set of rules for law enforcement, courts, and corrections that would permit little, if any, discretion. Justice should be exercised with swiftness and certainty. The main purpose of criminal justice should be to try to restrain and suppress criminal activity. If the criminal does not want to abide by society's rules, why should the criminal have the rights of society? The weaker the enforcement of law, the greater the likelihood of citizens being victimized. That's one argument. The other, or others, argue that because no case is identical to another, allowances must be made for wide degrees of discretion for law enforcement, courts, and corrections. So no case is really identical to another. So you can kind of think about that and which one you think should be there. Should we have less discretion or actually more discretion? Well, when we look at this finally here as we're ending up the criminal justice pendulum, the dual responsibility of seeking out the guilty while simultaneously protecting the innocent is one of law enforcement's greatest challenges. Now, the dualities within the system might be viewed as existing on the arc of a pendulum, with the needs of society, crime control, rigid adherence to policy, conservative crime control policies, and a view of the justice as retribution at the left end of the pendulum arc. At the right end of the arc are individual rights, due process, use of discretion, liberal crime control policies, and a view of justice as restorative. Sometimes the pendulum slows and is near the middle, kind of as it's almost there in the picture, but at other times it swings more heavily from one side to the other, which basically leaves us with the final thought of that responsibility that we have, that dual responsibility of seeking out the guilty while simultaneously protecting the innocent is in fact one of law enforcement's greatest challenges. And I would end with going back to that picture that we had on the very first couple of slides as we started this chapter 2 lecture of Lady Justice, the symbol for fair and equal justice without corruption or favoritism, often blindfolded to represent the idea that the judicial system is in fact impartial and blind to anything but the facts. And in her hand, you can see the scales of justice. And again, while it might seem very simple to balance those scales, it is in effect a lot more difficult than the average person can probably understand. So with that being said, that's going to conclude our Chapter 2 lecture. If you have any questions, please feel free to post them on the discussion board, or you can email me if you don't want to post them there. Also, don't forget to go back and look at the beginning of each chapter, the key terms. Make sure you know those, and go through the book, and also look at the discussion questions at the end of your chapter. So with that being said, until next time.